Welcome, dear participants, to the second session of this webinar on exploring patents avenues from basic to filing in pharmaceutical research. Continuous learning is minimum requirement for success in any field. Learning helps us to remain in touch with recent knowledge. So webinar is such a tool to keep learning from place where we are. I am Dhanashri Mai. Welcome you all to this second session of one day webinar. Webinars are always impactful when it includes real world example and experienced professional. In accordance with our mission to provide high quality education and training to pharmaceutical students, we are always trying to get real time experiences from skill and experienced professional. In our hand, we found Mrs. Swati Burde Tiwari, who is CEO of company. Ma'am is going to talk on roadmap for patent filing and drafting in process in India. As per as educational qualification is concerned, ma'am is bachelor in pharmacy and BA LLB. She is also a registered Indian patent agent and has completed diploma in IP from GIP, that is Global Institute of Intellectual Property. Ma'am has a huge experience in intellectual property right, that is 13 years of experience in intellectual property and innovation management field. She is a founder of IPR firm, that is ANS IP Management Services. Under that firm, she has filed more than 50 patents and 25 design patents and handle more than 250 patents in the field of biotechnology and pharmaceutical. The patent portfolio spans regional, small scale, and to the MNC also. The practice domain of MAM is pharmaceutical, biotechnology, and medical devices. With this very short introduction, I welcome you, ma'am, and handling this platform to you for sharing your valuable knowledge with us. Please, ma'am.
Hello.
Yes, ma'am, you can continue. Please.
Hello. Yeah. A very good morning to everyone. First of all, I would like to thank you, Gegate sir, for giving me this opportunity. And thanks for a wonderful introduction. So, without wasting any time, let us start with the today's topic of discussion. So, today I'll be talking about roadmap to Indian patent filing and patent drafting. The topics which I will be covering are what is patent, steps before filing a patent, who can file a patent, where to file a patent, forms and fees necessary for filing a patent, necessary timelines to keep in mind, Indian and international patent timelines, PCT filings, patent drafting, which is basically Form 2 for Indian application, and patenting by university students. As you all may be knowing, patent, what is a patent? It is an exclusive right which is granted to an inventor on his patented invention to exclude or to stop others from making, selling, or using his patented invention for a period of 20 years from the date of filing or from the date of priority. So, this is an exclusive right, and somewhere it is called a monopoly right also. So we will talk about this in detail in our coming slides. Okay, now let us talk about the steps before filing a patent. So when a person gets an idea, a new idea about any invention, so he has to first thing is he should not disclose his idea to anyone, because once it is disclosed, it will come into public domain and the novelty will be dissolved. So what you have to do is, once you have an idea, you should start working on it, start researching on it, and prepare a thesis or document, prepare a diary. You can maintain a diary and write about the novel points, then analyze the related prior arts or similar products, similar inventions in the market, and what are their disadvantages, or what are the problems which are being faced by the people in the market, and whether your invention is solving any such problem. Then analyze the benefits or advantage of that invention, or whether there is any difficulty level, difficulty of difficulty to achieve that product or that results which are not being able which are not being achieved by the person working in that field. So all these points we have to analyze. We can analyze the efficacy of the products, whether you have the invention the which you have invented is efficient. That is also very important criteria. So then you have to also analyze that whether it is monetizable, it can be commercialized, it can be sold, it can be sold to the market, or it can generate revenue. And yeah, study the similar prior arts and similar inventions in the market. Am I audible? So now, moving forward, what is an invention? Invention is defined as a new product, activity, or process involved with an inventive step and which is capable of industrial application. And it's one of the prerequisite for granting of a patent. So the main points for an invention to be defined is it should be new, it should have an inventive step, and it should be industrially applicable or commercialized. And when invention take place, it is an idea to product, and then the product it can be commercialized or it can be launched into the markets. Then only the rights of the patentee can enjoy his patent rights. So these are the three basic aspects of invention, that is novelty, inventive step, and commercialization. So for analyzing this, initially a patentability search is conducted. In that, we analyze that the invention is patentable, it is novel, or it has inventive step, that is, or it is also called as uniqueness, it has unique properties. So inventiveness is defined on various criteria, aspects, such as it is efficient, it has benefits or it is advantageous, it is easy to manufacture, or it reduces the cost of manufacturing, or it has a difficulty level has been taken care of, or means it is very easy to manufacture with less instruments or less difficulty. Then it is like quite beneficial. So this is how the inventive step or uniqueness is identified. This is a very gray area. Commercial aspect is like it can be monetized or it can be sold in the market. Why it is important? Because it is a monopoly right. It gives the inventor an exclusivity to protect others, to stop others from using your patented invention. Nobody can copy, manufacture, sell, or import your patented invention without your permission. So if it takes your permission, means they can be licensed out. There could be cross licensing. You can sell your patented invention. Then it helps in building business. You can use it to grow your business. You can earn royalties. Patent rights can be licensed to other companies to receive royalty payments. Sell, and you can transfer your patent rights in and tangible assets, like your rights are intangible. These are like your assets. So I will talk about a very brief about the criteria for patentability. Novelty, it must be new and not known publicly. It should not be patented anywhere in the world, and it should not be published anywhere. It should not be publicly known or traditionally known. Second is inventive step. I have already discussed about this, that there should be some technical advancement or some economic significance as compared to the existing knowledge that makes invention not obvious to a person skilled in the art. Person skilled in the art is the general person who has a basic degree in that field. Industrial applicability is capable of being made or used in an industry. So now I will discuss a bit about common types of patent applications in India. First is ordinary application. Ordinary application is called as the direct Indian filing, the first application which we filed in any country. So for India, if we are filing the application in India, it will be through ordinary route. It is called ordinary application. It is filed without any claim, without claiming any priority, or with reference to any previous application under process or with complete specifications and claims. It is always filed with complete specification and claims. Then second is conventional application. Conventional application is that has been filed in another country and then filed for the same invention in India. So this is also called as conventional route, and it is supposed to be filed within 12 months of filing it in that other country. Third is PCT, national phase filing. It is the patent application which comes through PCT route. So the national phase application is filed within 31 months from the international filing date. Then the last is PCT, international application. It is the PCT application, common application, which is filed in through WIPO, and it gives protection. It protects a priority in multiple countries, which all the countries which are registered with the WIPO. It doesn't give any protection, but it is just a route to get the time extension of 30 to 31 months to enter any international country. Plus, the PCT also gives the opinion, written opinion on the patentability of your invention. Now, mode of filing patents in India. There are three modes of filing patents in India. One is online filing, which is called e-filing. Then we can file it physically by post also, and in person also we can file. So nowadays, most majority of applications are being filed via e-filing mode, online mode. And the website is ipindia.gov.in. So this is the Indian patent website, and here we can see comprehensive e-filing. This is the e-filing portal for patents. Of course, this is in this you have to register, and individually also I think you can register, but usually patent agents have the rights to register, and they are patent agents will have all the 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 they have all the knowledge about how to file a patent, so better to go for with a patent agent rather than individual. Now I will talk about the jurisdiction, that is what are the Indian patent offices in India and where your jurisdiction lies, that is where to file your patent application. So there are 4 patent offices in India, that is in Kolkata, Delhi, Chennai and Mumbai. An application for patent shall be filed with the patent office having appropriate jurisdiction. So how to identify this jurisdiction is, so these are the states which are being controlled by each patent office. So in Mumbai, all these states of Gujarat, Maharashtra, MP, Goa, Chhattisgarh, and Union Territories of Daman and Diu and Dadra and Nagar Haveli. They go Delhi, the north zone of India like Haryana, Himachal Pradesh, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, all these states. The Chennai will take care of the southern states of India like Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana, and while the Kolkata takes care of the states of the western states of India. So now, how to identify your jurisdiction? First is you should be the applicant should be the place of residence or domicile or business of the applicant of the first mentioned applicant in case of joint applicant. So any one applicant who is having any residence or domicile. So based on that, they will identify their jurisdiction. For example, if you are based in MP, Bhopal, then your jurisdiction will be Mumbai. Then place from where an invention actually originated. This is also another criteria where the invention has been originated. Suppose it originated from Punjab, then that can also be the jurisdiction. Address for service in India given by the applicant when the applicant has no place of business or domicile in India. So if they are a foreign applicant, they should give an Indian address for service. For example, they can give address for service of their patent agent. Also, the further application referred to in Section 16 of the Act shall be filed at appropriate office of the first mentioned applicant only in case of divisional application. Now, who can apply for a patent? Any individual who claims to be the true and first inventor, assignee of the true and first inventor, maybe it could be a company or university or college. And so first is like individual basis also they can file jointly also, two or more individual persons or two or more individual and a company that they can also file. Then legal representative of diseased person, they can also file for a patent. Now flow chart for the patent filing in India. So this is the basic patent filing procedure. So once your application is filed in the Indian Patent Office, it will be published after 18 months. Publication is automatic. There is no form required for publication after 18 months. Yeah, if you want to go for early publication, then you have to pay extra fees and you have to request the office to publish your application earlier. So once that request is filed, they will publish your application by around 2 months of giving that request. So next is request for examination. So then we have to file request for examination. It is filed on Form 18 and we have to pay the official fees to the patent office. So once the request of examination is filed, the patent office will process your application and they will send an examination report, FER, that is the first examination report. So in that they will cite certain objections, and once we overcome those objections, the patent will be granted, and then you have to maintain that patent. So you have to file the renewal fees up to 20 years to keep that patent alive. So again, this is a flow chart. If we start here, so there are two types of patent applications we can make, that is provisional and complete. Provisional specification is filed just to protect your priority because it is first to file system in India, means the first who files the patent application will get the priority. So we suggest that whenever you get an idea, just immediately go for a provisional patent filing, and it is filed without claims. No claims are required. Just with the idea, you can just with the basic form, you can file it just to protect your priority. And then second way is to go for complete specification. If you think your invention is complete and it is marketable and all the research has been done, all the results have been achieved, you can directly go for complete specification filing. So once it is filed, then the patent office will process. Here I would like to talk about the withdrawal also. There is a provision for withdrawing the application also. So if you think that you have some more to add to the invention, then you can withdraw your patent application. It is for the rare cases it happens. Then so once it is withdrawn, your patent application will not be published. And the thing is that it has to be the request for withdrawal should be filed before publication. Once it is published, you cannot go for withdrawal of your patent application. Then complete specification, we'll talk about this in detail. Then After 18 months from the date of filing, it is published. It is published in official journal of the patent office, and it is open for opposition also, which is called pre-grant opposition. So your opponents can see it, and if they want, they can file an opposition for it. Then first examination report is issued. So there is no uh, timeline that when it will be issued, but usually, generally, it is issued by 6 months or 8 months from the date of publication. So we suggest that file your Form 18 earlier only while filing your patent application, because it goes in the queue of the examination. If you have not made the request, then they will not process. So we suggest that file your Form 18 at the time of filing or as early as possible. So it's a strategy. Some companies, they delay their examination because they have to keep their invention in public domain, or there are various other strategies which are followed by various companies. So they delay their examination, but it is always suggested to get your patent examined, because you will know that what are the where the invention is lagging, and that can be clarified, rectified. So once FER is issued, then you will get an you have to respond to that examination report. There is a timeline of 6 months. Within 6 months, you have to prepare an objection, and you have to overcome those objections. So mainly the objections are based on the patent act and rules. There are objections based on the novelty and inventive step, and could be sometimes commercial aspects also. Then there are some formal requirements also, like which are not been fulfilled. The fees are not paid, the forms are not filed properly. So that kind of rejections we get. So we have to fulfill those. And sometimes we get hearing also, if the controller thinks that still there are some clarifications required. So they will provide for a hearing. So we have to appear in that hearing, and we have to get the clarity on the those objections. And once it is accepted, the application is granted. Then if it is rejected, then there is a option of appeal also. We can appeal to the appellate board. Okay, now what is the priority date and what are the filing date? So priority date, it is a very important date. All your calculation of the timeline is from the priority date. Sometimes priority date is different and filing date is different. So for example, if you have filed first application in India, so your first filing date is your priority date. So all the timelines of examination, publication, they all will be calculated from that first filing date. So that's why this is called as priority date. Suppose we are going for international patents. As patent is a country specific right. So if you are, as my colleague has already explained, that it is a country specific right. If you're filing in India, then you will get protection in India only. If you see that you have market in other countries, then you have to go for patent filing in those individual countries. So that's why the filing date will change. So suppose if you're first filing in India, and within 12 months you are filing in US, so that filing date will change for the US application, and this date, Indian filing date, will become your priority date. So that is the difference between priority date and filing date. So now, difference between provisional and complete specification. Provisional is, as I have told, if you have an idea, based on an idea, you can file your provisional application. Provisional application is never published. After 12 months, you have to file your complete application. Suppose if you miss to file complete application within 12 months, then your provisional application gets automatically abandoned, and you will lose your priority. So hence it is suggested that file your complete specification within 12 months to keep that priority. So losing your priority means that during that 12 months, another person or your competitors may file for that same invention. So they will get the rights. You will lose the rights. So that is the basic major difference. That's why it is very important to file complete specification. And as I've told, provisional is just filed with idea. It could be one page idea, two-page idea with minimum idea, and as broadly as possible, as generic as possible, you can describe your invention. No specific technicalities are required in provisional. But when you and there are no claims actually. The major difference is there are no claims in provisional. For complete specification, you need to have complete details, complete data ready, experimental details, results ready. With claims, you have to file complete. So claims are basically the legal part of your patent application. So here it is said, so in provisional, you can file description, objects, background, and the prior arts. In complete specification, the only difference is the claims part. Now, the forms which are required for the patent filing are basically it is Form 1, which is the application for grant of a patent. Form 2, it is the provisional and complete specification. Form 3, it is statements and undertaking, means that it is basically like if you are filing your patent application in any international countries, you have to keep informed the patent office with all those activities. Like for example, if a patent is being examined and examination report has been generated in that international country, then you have to file Form 3 regarding that this has been filed, and it is supposed to be filed within 3 months of that uh, activity. So we have to keep filing Form 3 every 6 months. Then Form 5, it is declaration as to inventorship, like these are the true inventors of this invention. And Form 26, it is optional. If you are filing individually yourself, then it is not required. But if you are going through a patent agent, then you have to file Form 26. Then further forms which are required at a later stage are Form 9, as I discussed. This is for the publication, early publication. And then, so if you, as I told, that if it is early published, then it will be examined earlier. Chances, yeah. And Form 18 is for request for examination. This is normal. And Form 18A it is for expedite examination. So this is the latest amendment which has been done, that we can expedite the examination of patent application. I'll discuss about this later. So now, so how we can file? So there are two different classification which the patent office has done. We can file as an individual, small entity, startup, or educational institutions. So these are one criteria, one classification. Other is large entity, which is other than natural person, startup, entity, educational institutions. So the fees are separate for these two. For example, Form 1, if we see, the fees is 1,600 for individual, startup, small entity, and education institutions. Rather, for large entity, it is 8,000. So for startup and small entity, and this we have to give a document, maybe MSME certificate or startup certificate, to we have to submit that. Then only we will be getting this. We can claim this concession. So there is a Form 28 for which by filing which we can claim this concession. Similarly, for Form 18, which is for examination, the fees is 4,000 for individuals, startups, small entity, education institutions, and 20,000 for large entity. Form 9, again, it is a publication. So this is the fees. And all the data is available in the Indian Patent Office website regarding the fees and the necessary forms. Everything is available. Now, I will talk little about patent opposition. So I already told pre-grant opposition. So which this can be filed within a period of 6 months from the publication of an application. Usually, it is filed by the parties interested. Interested party means your competitors. And once it is filed, then it this is a hearing, means the process, parent office office takes it and call for hearing, and there are all the procedures are there. Post grant opposition is usually after the patent is granted. So again, interested parties can go for post grant opposition. Then again, yeah, the patent office considers it, and there is a proper procedure which goes on. Examination happens, hearings happens, and then if they feel that yeah, it can be opposed, then the patent is opposed. Otherwise, the application is opposition is rejected. Now, once the patent is granted, you have to keep it alive. You have to pay the renewal fees to the patent office. Usually, it starts from the third year and it goes up to 20th year of the patent lifetime. If it is delayed, then the patent lapses. So it can be renewed. There is a procedure. You have to file a request for getting it activated. Restoration, it can be restored. Now I will talk about the patent drafting process. Though it is a very critical and cumbersome process, it requires skills. So I'll try to cover it in an easy language. So first of all, a patent comprises two parts: specification and claims. Specification is the technical part, and claims is the legal part. That's why patent application is called a techno-legal document. So which requires both legal and the technical skills. Patent define the scope of an invention. Claims define the scope of an invention. So whatever you are claiming, you will get protection on that. So all the infringement suits are filed in that we consider the claims actually. In specification, we describe the invention in the best possible manner. We have to provide all the details of the invention, its working, its characterization, the experiments performed, the drawings, with the help of drawings and graphs, and the results obtained, the advantages. So I'll come to it one by one. Okay, the parts of claims. A claims has usually three parts. One is the preamble. Preamble is, it should be as generic as possible and it should match with the title of the invention. Then transition term. Transition terms are usually called as comprising, consisting essentially of, and consisting of. So there are varying scopes with transition terms. Comprising is considered as broadest, which can encompass additional elements we can add. Consisting, it's essentially of, it compasses additional elements that do not affect the essential features of the invention. And consisting of is the narrowest one, which usually we avoid using, but in certain conditions where your invention is, where you see there are lots of prior arts and we just want to claim a small part of it, a small scope, we want to keep a very small scope, and we say we will not interfere with the others scope, so we use consisting of in rare cases. So mostly we use comprising. And the body recites all the essential elements, and then further, and how they are related to each other. So that forms the body of claim. So usually there are two type of claims. First is independent claim. Independent claims is the first claim which forms the scope of your invention, which you want to claim. So it should be in a broadest possible manner, but it should not be as broad as uh, include the prior arts also. So it should be narrower to just to overcome the prior arts. So that's how, like, suppose for example, if you want to claim a property, right? If you want to claim a land, how do we claim? We claim it like on the east this is there, on the south this is there, on the north this is there. Similarly, in patents, we have to draft the independent claim um, in the broadest possible manner. For example, I'll explain you in my later slides. Then dependent claim. So dependent claims are the claims which depend on the independent claim. That is the first claim. And these are the further elements which we want to claim, specific elements regarding the any component of the independent claim. For example, uh, see here the first claim is a method of lowering cholesterol in a subject. Okay, so method claim. First of all, I would like to tell that method, there should be, the language should be ing, means it should have the steps. Steps means adding, making, heating. So this is the language we use for claiming a method. So here the preamble is a method of lowering cholesterol in a subject. This is the preamble. Comprising forms the transition element. And next, administering to said subject compound X or a pharmaceutically acceptable salt thereof. This forms the body of the claim. Claim 2 is the language, if you can see, is the method of claim 1, wherein. So this is a dependent claim which is depending on claim 1. Similarly, third claim, here it is saying the method of claim 2. So this is a independent claim which is depending on claim 2. So these are further saying wherein the subject is human, wherein the subject, said subject. So said means we are defining, we are pointing out, we are talking about this subject, which has been explained, which has been already mentioned in the first independent claim. This subject, it is a human. And then third claim says wherein said pharmaceutically acceptable salt is a sodium salt. So further we are narrowing down, right? So said pharmaceutically acceptable salt has already been talked about in the first claim broadly. Now we are narrowing it down to sodium salt. So here actually we follow a funnel approach. Funnel approach means first independent claim has to be broad, and then dependent claims will go further narrowing down. Another example, a nanoparticle comprising. So a nanoparticle is preamble here. It is very general. We are not saying what and what kind of nanoparticle, maybe because this is too general. So examiner will never allow this. A nanoparticle, there has to be something. But just for an example, so this is a preamble. Comprising, here is a transition element, an antibody bound to a polymeric nanoparticle core. So we are claiming this in this. So this is the scope we have formed here. Now the nanoparticle of claim 1, the nanoparticle. So here articles are very important in claims. The, said. Said is now not in use. Usually we use the language. So further we are narrowing down independent claims. This is again a method claim, a method of diagnosing disease X comprising. Now here you can see the steps. Taking a body fluid sample, contacting said sample with a probe, detecting abnormal genes. So here it is the steps which are being followed. So this method has to be novel. There should be novel steps. Then only you will get grant for the method. This is an example of the compound. How can we claim a compound, a pharmaceutical compound, a formula? Then we can claim the formula. Then there are other types of claims, which is called Markush claims, which is used mostly in pharmaceuticals. So if suppose we want to claim many components in a group, so we use this language wherein suppose, for example, R1 is an element. It is selected from the group consisting of alkyl, alkene, and aryl, and so on. Means any number we can add in this group. So they all are, so that R1 could be anything from the mentioned compounds, wherein said stabilizer comprises at least one member selected from the group consisting of. So this is the Markush language. selected from the group consisting of. This is actually the Markush language, which we have to follow. Then product by process claim means any product, new product which is being made by a process. So there, this is very still debatable topic, product by process. Now I'll talk about the specification drafting. So specification has, which is Form 2 of Indian patent. So it has various headings, various parts like title. Title should be as generic as possible. There is a word limitation of 15 words for the title. Then second is the technical field. We have to tell which to which our to which technical field the invention relates to. Then of invention, it gives the introduction or basic background about the invention, that what is invention about. Then what are the prior arts, what are the similar patents which are there in the market, or what are the similar products. Then we have to mention the drawbacks of those prior arts or those products. And then in the end, what is the need of doing the invention. So that is how a background should be drafted. First, you can start with a basic introduction about your invention. If it is a product, you can start with that. If it belongs to some technical field, that technical field can be introduced. Then talk about the prior arts, and talk about the drawbacks of the prior arts. And then in the end, talk about what are the needs, what is the need of doing this invention. Then comes the summary. Before summary, there are objects. Sometimes in objects only, summary is the objectives are the parts of the summary. So object is, why are we doing the invention, what are the advantages of the invention, and what problems we are solving. So those form the objects of the invention. In summary, we will write a brief about the invention. Basically, summary, we paraphrase the claims, whatever we are claiming. We usually paraphrase it in sentence form, and we draft the summary of the invention. Then detailed description. Sometimes, yeah, before detailed description, if there are any drawings and graphs, we write a brief description about the drawings and the graphs. So we have to explain about briefly what is the figure 1 relates to, figure 2 relates to, figure 3 relates to, and so on. And in detailed description, then we will describe our invention in best possible manner. All the embodiments we have to explain, working of the embodiments with respect to drawings, and explanation of the drawings. And if if there are various formulations, then by way of examples, we can explain all the possible embodiments or examples, also we call it. And the best mode is also very important as per the Indian laws. So what are the best possible embodiments? See, controller patent office will not give grant to everything. Okay, so sometimes we have to narrow down our claims to get the grant. So this is all about detailed description. Then claims we already talked. Then abstract. Abstract is the word limit for abstract is 500, and we should in abstract, now it is important to describe the invention, to talk about the advantages of the invention, the necessity, the need for the invention, and little bit you can explain about the main points of the invention. So yeah, the background describe field of invention, and it may describe the limitations of the closest prior art. Summary involves the objectives of the invention, brief description of the independent claims, and statement of utility. So detailed description, all the dependent claims and all possible embodiments. So this was all about the patent drafting. Then now some points I will talk about the universities, patenting by university students. So there is a fee reduction uh, after the amendments have been happened, and the official fees has been reduced. to individual for the educational institutions. And there is a provision of expedited examination, which I told that you can file form 18A. So it is done on two ways. One is that you can uh, convert your normal application into expedite application, and second is directly you can go for expedite application. Then students can sell their patents, they can license out their patents, and they can earn royalties. And they can collaborate with R&Ds. Students get easy opportunity to collaborate with R&D bodies at early phase of their career, and it adds to their value to their career. Now, little bit I want to talk about the role of patent agents. Why it is always suggested, recommended to go with a patent agent, because because the researcher is more into researching. He knows more about the technicality of his invention, rather than patent agents will know the legal aspects of your invention, of patenting it. So a patent agent will help you to he helps you and guides you to get the patent for an invention. And he will represent your patent application, and he will guide you to analyze the patentability of an invention. If it is sometimes it is like you will find that it is not patentable, then we suggest then how to make it patentable, how to make some changes, and which way you can make the changes, and you can get the grant for that invention. Then he can draft the strategies for enforceability of the patent. And they have the expertise of getting the patent if in examination report you get rejections. So we help you how to amend the claims and get your patent granted. We will draft your application in the best possible manner, and we define the scope of your invention. So these are all the roles of patent agents. So thank you. So it is all about this. I hope you understand. You understood all the points. I have tried to touch most of the points, but the topic is quite vast and the time is less. So if you have any questions, then please let us know. Let me know.
ಗೊತ್ತಾಯ್ತು.
ಗೊತ್ತಾಯ್ತು.
Thank you, ma'am. I think you have explained very nicely and clearly so that we have not received any question yet. Just we have received one request
Okay.
that they are asking, actually, two or three participants are asking that whether you are able to share this PPT with us or not.
Okay, I'll share. No problem.
Actually, we have received one comment and I would like to show you.
Okay.
Deepak Kokre saying that it is very nice session.
Thank
Thank
you.
you, ma'am. Yes. Thank you, ma'am, for providing A to Z information on patent in India. Ma'am, you have nicely explained the importance of provisional application, different forms for patent filing in India. Ma'am, also you have explained actually a patent is a very complicated and legal draft, but you have explained it in very simple words, which can be understood by all the participants. You have also explained the patent with different patent examples like method patent, compound patent, pharmaceutical salt patent, and some product patent, and also the importance of specific drafting. Thank you so much, ma'am. Please accept this certificate as a token of love from us. Please, ma'am.
Thank you.
Thank you, ma'am, for sharing your valuable time with us. Thank you so much.
Thank you.
झालं ना? आता left झालं.
Stream नहीं रहेगी. Net. थांबा थांबा माझं करा जॉईन पाहिजे. करा करा जॉईन कर माझं. चलो